Friends, we are starting now. Today is the 235th Friday group meeting. Our speaker is beloved friend, Senior Advocate Mr. Sridhar Potaraju. Even earlier occasion also on 233 Friday group meeting, that's the 25th 10/24, he addressed Part 1, that is Constitution Bench judgment dated 17/10/24. Section 6A of the Citizenship Act 1955 pursuant to the Assam Accord dated 15/8/1985. So we are Part 2. That time we explained only few facts about the overall issue of the Assam background, what made them to make accord and other thing. Today is on pure law according to our speaker. So now I request Sridhar will start, initiate.
Good afternoon, Seshu sir, and good afternoon, dear friends. I would like to place the Supreme Court judgment on the validity of Section 6A of the Citizenship Act, which was enacted in 1985 pursuant to the Assam Accord, which was a political settlement between the agitating groups of students and others in Assam protesting the illegal migration from Bangladesh into Assam and then settling down in Bangladesh. Bangladesh is in the territory of the state of Assam. On the last occasion, I had placed the historical backdrop of this accord, which was based on understanding and a political settlement which the government of India had entered into, and the parliament stepped in to bring some peace to the agitation which was on for more than 6 years. Today I would like to place the broader contours of the legal arguments that were raised and addressed by the Honorable Bench through the lead majority opinion of Justice Suryakant, who has authored this judgment of the majority. The other two opinions are the concurring judgment of former CJI Justice Chandrachud, concurring with the majority, upholding the constitutional validity of Section 6A, and a very erudite dissent by Justice Part2. Today I would like to place the merits of the judgment of the Supreme Court while upholding the constitutional validity of Section 6A. Broadly, the issues which were considered, on which I would like to dwell today in the course of the talk, would be on the scope of judicial review, fraternity, Part 2 of the Constitution vis-a-vis Section 6A. So, the validity of Section 6A of the Citizenship Act has been challenged on the basis of the preambular fraternity as a principle. Then also on Part 2, very rarely we come across a challenge of any provision of statute under Part 2. So this case deals with it. So I would like to place that at length. And thereafter, the challenge under Article 14, manifest arbitrariness, etc. is there. Then also an interesting argument based on Article 29, 326 adult franchise, as well as 355 of internal and external aggression being grounds as an internal and an external threat to the integrity of the state of Assam were also raised as arguments. To begin with, I would like to draw your attention that the court, through the lead judgment, has examined the scope of judicial review. Since we have enough jurisprudence which is settled on the subject of judicial review, due to constraints of time, I would like to confine my presentation qua judicial review limited to the observations that the court has undertaken the exercise of judicial review of this decision, which the Union of India had objected to as being beyond competence or beyond the scope of a judicial review, on the premise that there is a foreign policy which is at stake, and also a matter of pure policy that the government can take certain decisions. which are beyond the realm of a judicial review. The court has not accepted the submission and held that it's not purely in the realm of policy once the policy is reflected in a statute by way of an amendment. Section 6A has been incorporated into the Citizenship Act in 1985. Therefore, the vires of a statute is well within the scope of judicial review in a proceedings before the constitutional courts, either under Article 32 or under 226 before the High Court. So in that sense, the power of judicial review has been upheld in this case, and therefore the writs were considered on their own merits. Now the second limb of this challenge is more on the issues of various provisions of the Constitution being violated. Now the first thing that comes to our mind would be the challenge on the grounds which are very unique in this case. Fraternity has been put to the forefront as to what is fraternity and how does the concept of fraternity in the preamble play out in a judicial review test of any statute. So what is fraternity is the question that has been canvassed before the court, and the court had an occasion to go through this issue and then come to a view that fraternity in the preambular concept is inclusive and not exclusive. Because the argument of the petitioners was that fraternity had to necessarily exclude those people who were being given the benefit of citizenship under the Section 6A regime. As we all know, the regime of Section 6A conferred citizenship for people who have entered prior to 1971, and it does not apply to people who have entered Assam or started residing in Assam post 1971. So the cutoff date for the applicability of the Act has been set out. Now, the people who had come and settled down till 1966 were given the benefit of citizenship upfront pursuant to this Act, the amendment, whereas people who had come between 66 and 71 had been put on a observation period, if I can use that phrase. If they were already in the electoral rolls, their voting rights were suspended for a period of 10 years. Thereafter, on compliance with the necessary procedures prescribed under the Act and the rules framed thereunder, they could be considered for grant of citizenship after determination that they were illegal immigrants to begin with by the state. So the court was considering whether the argument of the petitioners to exclude a certain set of people on a constitutional premise of fraternity can be accepted or not. It is in this context that the court has proceeded to hold that fraternity in the constitutional scheme does not exclude, but actually it includes people. So our constitutional understanding of fraternity cannot be on a threshold of exclusion. That is, that you exclude people on a premise of othering them. So that's not the spirit of the preambular values that the Constitution has, insofar as extending the benefit of citizenship is concerned. So Section 6A has been held to be completely in alignment with the constitutional spirit of common brotherhood of all citizens. So therefore, the trinity of equality, liberty and fraternity, if I may just quote the code, the court has often reiterated that the ideals of liberty, equality and fraternity should not be treated as separate entities, instead should be viewed as a trinity that secures empowerment and political justice for all citizens. Additionally, fraternity was interpreted as a principle that afforded the means to achieve national unity and dignity of the individual. So therefore, what was stated and then held, the concept of fraternity being exclusive has been rejected by this majority view. It has held that the essence of fraternity is fundamentally geared towards fostering interconnectedness among Indians and was envisaged to be a principle of uplifting marginalized sections of society. Consequently, it also holds it is antithetical to the essence of fraternity to deploy this inclusive constitutional value in a way which deliberately excludes large swaths of the population who have been duly conferred citizenship through procedure established by law from the protection of constitutional rights. It says that people intermingle and then fraternize, and therefore once the law chooses to give citizenship, though it was under challenge before the court, it says that this cannot be a ground per se to actually put at naught the benefits or the underlying values which the preambular concept of liberty, equality and fraternity, which had to be played out through the legislative act of granting of citizenship on account of the settlement which is the Assam Accord. The next part of the challenge will be on the ground of Part 2 of the Constitution. Now, what does the Part 2 of the Constitution deal with? It deals with citizenship. So, if you look at Part 2 of the Constitution, the sections in questions will be, articles would be 6, 7 and 11, which have been put in question. 6 talks about rights of citizens of certain persons who have migrated to India from Pakistan. 7 talks about rights of citizenship of certain migrants to Pakistan, and rights of citizenship of certain persons of Indian origin residing outside India is Article 8, and Article 9 talks about persons voluntarily acquiring citizenship of a foreign state not to be citizens. Article 10 talks about continuance of rights of citizenship, and Article 11, Parliament to regulate the right of citizenship by law. So, the exercise of the power under Article 11 resulted in the Citizenship Act, and the enactment of the 1985 amendment brings in a new category of people who were conferred citizenship in addition to the other modes of citizenship available under the Citizenship Act of 1955. This was a political settlement, as I had mentioned earlier. So there were people who were agitating on the question of permitting settlement of people who had migrated from Bangladesh. So the cutoff date was a bone of contention, and as per the Assam Accord, 1971 was the cutoff date upon which there was an agreement. The agitators initially had been canvassing that the cutoff date should be 1951, but due to various reasons, including the friendly relations with Bangladesh, that the government of India had persuaded the agitating people of Assam to agree for a cutoff date of 1971. The Citizenship Act under Section 6A seeks to identify and deport people who have migrated post 1971. It is a different story that the procedure ought to have been adopted was not successful, and thus that probably has triggered the belated challenge to Section 6A of the Citizenship Act at a much later date. Now, in this background, if you look at the scheme of this judgment, the constitutional philosophy of Article 6 and 7 is to safeguard the rights of individuals who were previously Indians but found themselves residing in a foreign territory due to political circumstances surrounding the migration. So now we all know, through history, most of us were not born at that point of time. From the annals of history of our own land and its independence, we all have heard stories of the bloodbath leading to the partition and thereafter. So people, if I may just digress here and say that the identity of the people of this land was always people who are referred to as Hindustanis. The Hindustani reference is coming from the Sindhu river. Sindhu has now evolved into be a Hindu, and Hindustanis are people who live in this land. And the irony of the partition is that the major portion of the land, which is Sindhu, is now not part of the major part of Hindustan as we all know it. Be that as it may, the identity of the people was common, but for the political boundary which was drawn pursuant to the independence. The reasons for the partition we all are aware, and it had caused a lot of distress to several individuals and groups across the border on both sides. A large-scale migration did happen. So it is in that context that the acknowledgement of the origin of a common ancestry and descent in this part of the land, which was known as India or Hindustan or Bharat prior to the independence and the partition, was acknowledged by the Constitution itself under Article 6 and 7. Article 6, Section 6A also is based on the same underlying policy reason of granting citizenship to people of Indian origin migrating from Pakistan due to political disturbances in a foreign territory. So the cutoff dates for Article 6 was people who were in 19 July 1948, whereas the cutoff date for Article 7 was 1st January 1947. Now, the difference, if I may just refer to Article 6 and 7 here, to put things in better perspective. Article 6 is dealing with a situation where people have migrated to India from Pakistan. So the people who had come into India on or before 19 July 1948 were conferred citizenship under Article 6, and rights of citizens of certain migrants to Pakistan. So those who had initially migrated from this part of the country, the territory India, to Pakistan, were also given a limited right to return within a certain period on the basis of certain permits. Section 6A now has created a subsequent period with two periods identified distinctly. The period of on or before 1st January 1966 were granted deemed citizenship forthwith, whereas those who had come on or before 25th March 1971, they were made to be identified as illegal immigrants through due process and then wait for a period of 10 years before they were conferred full citizenship. Till then they were having the benefits of citizenship minus the voting rights. Even if they were already enrolled, their enrollment was to be suspended or cancelled until it was restored 10 years later. Now 25th March 71 becomes the period cutoff on which anyone who has entered thereafter would not be getting any benefit of this Section 6A. So Article 6 does not prohibit granting of citizenship after the cutoff date of 19th July 1948, because the challenge laid before the court was that the violation of Part 2 was on account of a understanding or a proposition canvassed by the petitioners that it violates Article 6. So it is in this context the court had an occasion to hold that there is no bar under Article 6 to grant citizenship after 1948. Similarly, Article 7 prohibits citizenship to people who have re-migrated to India. Section 6A granted citizenship even to people who migrated for the first time after that cutoff date. Now the question was, what is the state of Pakistan that we are referring to? Because an argument was raised. East Pakistan, which now is known as Bangladesh, was not covered by these provisions or was not covered by the permit system which allowed people who had migrated to Pakistan to return back. It is in this context that the court clarifies that there was no concept of Bangladesh as a sovereign state. So therefore, reference to Pakistan under Article 7 would necessarily include East Pakistan as well, and in any event, it does not prohibit in any manner the Parliament from enacting any law governing citizenship forthwith or thereafter. So Article 11 with entry 17 of list 1 of the 7th schedule, which deals with citizenship, naturalization and aliens, and entry 19 admission into and emigration and expulsion from India, passports and visas. So Article 11 speaks of nothing in the foregoing provisions of this part shall derogate. So the reference is to this part. So it refers to Part 2 as a whole. So the power conferred on the Parliament to enact is not confined or in any manner restricted by any of the provisions of Part 2. So Article 11 enables the Parliament to pass any such law as it deems appropriate to confer citizenship. So therefore the challenge primarily an attack on the ground of violation of Part 2 per se and individually Article 6 and 7 was rejected on this premise that the power to enact the Citizenship Act and the amendment under Section 6A is conferred by the Constitution itself under Article 11. This power of the Parliament has already been recognized by an earlier judgment in Nizar Ahmad Khan, which is cited in this judgment. In para 138, the lead opinion of Justice Suryakant actually extensively explains with great pains all the nuances of Article 6, 7 and how Article 11 is independent of any limitations which were prescribed under Article 6 and 7. So therefore, the challenge to Section 6A was rejected, stating that it cannot be impeached on the ground that they go against any of the other articles of Part 2. So the court takes strength from the earlier Constitution Bench judgment of 5 judges in Nizar Ahmad to hold that Article 11 is the source of power which enables the Parliament to enact laws on citizenship and to confer citizenship. So in fact, here it is in this context, they also examine the language which was considered by the Constituent Assembly. Initially it was proposed to use the phrase any further provisions. So instead of the language it eventually uses, nothing in the foregoing provisions of this part shall derogate from the power of Parliament to make any provisions with respect to acquisition and termination of citizenship and all matters relating to citizenship. If I were to read the draft as it was, the language would have been to make any further provisions. So any further provisions would have actually restricted the scope of any future legislations and the Parliament's power to enact in derogation of Article 6 and 7, which is the premise of the challenge of the petitioners. That proposition or the proposal to have the phrase any further provisions was rejected, and in lieu thereof, what was accepted was any provision. So it's a broad, open-ended power without any restrictions conferred on the Parliament to enact. So Parliament has been held to be possessing legislative power to enact laws concerning citizenship, and this is not restricted by the Part 2 of the Constitution. So now the categoric decision of the majority is that Part 2 cannot be stated to have been a limiting factor on enactment of Section 6A by the Parliament. So therefore the Parliament has the necessary power to enact any law governing citizenship for the periods of future for which the provisions of the Part 2 do not provide for, and therefore Article 11 becomes the source of power for making any necessary laws, including amendments to the laws so made. So the law here being the Citizenship Act 1955, and the amendment in question was made in 1985. An interesting argument was also raised. Would it not amount to granting dual citizenship? Because in a normal course, the citizen in Indian context is only a single citizenship. You either have Indian citizenship or you abdicate Indian citizenship and adopt a new citizenship. In the event you take any other citizenship, this judgment very categorically states the law that there is an implied giving up of your citizenship. So we have come across cases, in fact of some politicians also, so from our part of the state, whose citizenship was stripped because he as a student had taken citizenship in Germany, as I remember, and thereafter the question, he came back, contested elections here, and his citizenship was questioned, that his citizenship as a German was not fully abdicated and he had retained the lien on that, and he did not fulfill the procedural requirements of the Citizenship Act. So that was gone into under the proceedings initiated under the Citizenship Act, and thereafter the citizenship was actually cancelled. So a certificate of citizenship given on the strength of which he had contested elections and won as well, the citizenship was cancelled. So therefore, Indian constitution does not acknowledge or permit dual citizenship. So therefore what we see, the overseas citizens of India, etc., are not citizenship per se, but there's something short of that which acknowledges the descent, the rule of descent of people of this country's origin who may have migrated to any other part of the world and whose children are treated as people of Indian origin, as PIOs are there, or overseas citizen of India. So that concept is evolving. See, with the globalization, I think the parliament is in need of that power, and the constitutional framers have therefore provided that unhindered power through Article 11. Now, when we talk about dual citizenships, the challenge was that the immigrants did not renounce their citizenship before they were granted Indian citizenship, and therefore Section 6A is unconstitutional for violating Article 9. Now, Article 9, persons voluntarily acquiring citizenship of a foreign state not to be citizens. No person shall be a citizen of India by virtue of Article 5 or be deemed to be a citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. So it is a case where anyone takes voluntarily a citizenship of any other country. So by virtue of Article 9, they lose their citizenship. Here, the termination of citizenship, as we are talking about, is by operation of Article 9. Therefore, a person who acquires voluntarily a citizenship will be denuded of his Indian citizenship. Any immigrant who has been granted citizenship under 6A, if found to have dual citizenship, Section 9 of the Citizenship Act, which deals with the procedure for cancellation, can be invoked to hold such person has ceased to be a citizen. So the court recognizes that there is a presumption of citizenship under Section 6A, but if it is found, it is a rebuttable presumption that in case a person has been found to be exercising the privileges of his earlier citizenship, which necessarily rebuts the presumption of renouncing their earlier citizenship, impliedly or otherwise, then proceedings under the Citizenship Act can be invoked to cancel their citizenship, which was granted even under Section 6A. In fact, the court goes further to hold that Section 6A is not a safe harbor from Section 9. If you look at Section 9 of the Citizenship Act at this moment, Section 9 deals with termination of citizenship. So the procedure for termination of citizenship can be invoked in accordance with the law which governs the grant of citizenship itself. So a natural born Indian who acquires a foreign citizenship and does not give up this citizenship can be questioned, and then proceedings can be initiated through a proper mechanism or the procedures available to anyone to raise an issue on this count. I believe there's some proceedings happening in Delhi also for a popular politician. We'll have to wait and see what is the challenge and the nature of challenge and the scope of challenge. I had no opportunity to know the details there. Then implied renunciation of citizenship is one other issue the court clearly spells out. It recognizes that several constitutions have similar provisions globally, which say that by acquiring their citizenship, it is implicit that you've given up the citizenship of any other nation that you may have taken earlier. Now, another ground of challenge was Section 6A and Oath of Allegiance. The argument was that under the Citizenship Act, an Oath of Allegiance is required under Section 5.2 as citizenship is being conferred in a deemed manner, and every adult who's given a citizenship having not taken the Oath of Allegiance, he's actually in violation of the mandate of the Citizenship Act, and therefore Section 6A seems to be contradicting the mandate of Section 5.2, and a challenge was being set up on this premise itself. The court holds that the Indian Constitution per se does not actually mandate an oath of allegiance of citizenship. It comes through section 5.2 and section 5.2 alone. So therefore, the procedural requirement of section 5.2 cannot be enlarged to challenge the vires of an amendment act which introduced section 6A. The overarching mandate of the constitution does not provide for an oath of allegiance as a necessary legal prerequisite. The enactment, namely the Citizenship Act 1955, has consciously confined the mandate of oath of allegiance as held by the Supreme Court in this judgment to procedure under 5.2, which is again governed in terms of the language of the provisions of section 5.2 itself. Now if we look at section 5 and 5.2 for a moment, this deals with citizenship by registration. And then 5.2 talks about no person being of full age shall be registered as a citizen of India under subsection 1 until he has taken the oath of allegiance in the form specified in the second schedule. So therefore the requirement of 5.2 has been very restrictive only for people who are given citizenship by way of registration under section 5.1. So the challenge on account of absence of an oath of allegiance is also rejected on this count itself. So this is where the technical arguments under Part 2 as well as the argument under the Citizenship Act have been dealt with, and the arguments were rejected, commencing with the challenge on the scope of judicial review, the opposition by the union and those who were questioning the maintainability of a judicial review in a matter of this gravitas was rejected, and the writ petitions were entertained on their merits. And on merits also, Part 2 as well as section 5.2 arguments have been rejected by the Supreme Court. Then the court proceeds to consider the challenge on account of violation of Article 14. So the broad challenge, if I may just summarize because of paucity of time, under Article 14 was under inclusion because it says that section 6A is confining state of Assam and excludes other states which had similar challenge of illegal immigrants, namely West Bengal. Further, it also says that you have discriminated to burden the state of Assam with this citizenship rights, while the other states were not required to be taking the similar burden. So this was the broad challenge. In addition, the question of manifest arbitrariness was also raised. Manifest arbitrariness, Tata Cellular onwards, the law is now very clear that that itself is a ground for striking down a legislation. Now the court says that the argument cannot be rejected at a preliminary stage with reference to the law declared in Anwar Ali Sarkar's case, which held that all persons similarly circumstanced shall be treated alike both in privileges conferred and liabilities imposed. So therefore the opposition to a challenge on this ground was rejected. The opposition was that this ground cannot be actually developed and it needs to be curtailed at the preliminary stage itself, because it was effectively canvassing a right of being burdened similarly and not actually a privilege being conferred similarly. So the court relies upon Anwar Ali Sarkar's case to hold that a negative burden which is imposed on one as against the others could itself be a violation of Article 14, as was already held in 1952, Anwar Ali Sarkar. So the argument based on Article 14 was held to be maintainable. The court then examines this issue as coming out of a political accord, a political settlement which brought peace and the agitation which was on from 1979 to 1985 for a period of 6 years, which had disrupted the academic schedule of several batches of students and the social life, had come to a quietus. So therefore the parameters for testing it will have to be a little more sensitive. because it involves a political decision making, which is the exclusive domain of the elected representatives and not the unelected, namely the judicial. So the court observes Section 6A inserted to advance political settlement established through Assam Accord serves as intelligible differentia vis-a-vis other states. So the court says that you need to compare yourself with the other states of the nation and not only one state. So applying that yardstick, the court upholds that the intelligible differentia for this classification is valid. The next challenge was the federal structure argument, namely one state is being discriminated against the other states. The court again holds that the peculiar situation and circumstances of each state can be dealt with independently by the parliament as it thinks appropriate, and therefore federal structure would not mean a blind application of equality across board, because every state has its own unique challenges and needs which need to be factored in a federal constitution like India, with so many states which having different aspirations. Here, if I might say, the creation of states or union territories also is a exercise which is undertaken by the parliament after following the necessary procedure. So therefore the identity of the state itself is not something which is beyond the power of the parliament to be altered geographically or otherwise. See, the reorganization of states that we have experienced right from 1956, the first major reorganization of states, till 2014 when Telangana was formed. So reorganization of geographical entities as states has been an ongoing process. So therefore the identity of the state per se is not that sacrosanct as the right has been asserted qua one state. So therefore the court says one state, remaining others should be treated as a comparative yardstick, and also a state specific enactment is permissible and it doesn't fall foul of Article 14 is what the court comes to a conclusion. So the next challenge was on account of manifest arbitrariness, etc. So manifest arbitrariness has also been rejected on the premise that this exercise is a political exercise. I mean, the court is always circumspect about the challenges that the state, the Union of India has to face, and then the challenges have to be met with political dynamism and pragmatism. So in this context, the court examines in detail of the facets of manifest arbitrariness, and thereafter it proceeds to reject the arguments as well on the basis of the well-settled principles holding that the classification is valid, there is an object which is sought to be achieved, and there is an intelligible differentia in the classification, and there is a complete cohesion in all three: object, the classification and the method adopted. So therefore the Article 14 challenge also stood rejected. Now if you look at a very interesting challenge on account of Article 29. So Article 29 is the cultural rights, as we all know. So the subheading deals with minority rights. It is now well settled that the Constitution has in fact recognized that the rights under Article 29 are not confined only to the minority, but they are available to any section of the society. If I may just, for convenience of refreshing the language of Article 29, read it. Protection of interests of minorities is the subheading. Any section of the citizens residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. So therefore the right has been conferred to people who have a distinct language, script or culture, and also a right to conserve the same. So if I may just read out from the language used in interpreting this article from the judgment itself. Article 29(1) effectively has two key aspects that need to be determined. First, whether there is a section of citizens seeking to conserve their language, script or culture, and second, that such language, script or culture in question is distinct. The Article 29(1), while conferring the right to conserve, does not restrict itself only to the notion of a minority as understood in the technical sense, but includes any group that may seek to conserve a distinct language, script or culture. So with this kind of an interpretation, the court proceeds to hold that we are dealing with a very complex issue which was putting the state on complete unrest, social, political unrest. And it had been brought to quietness through a political settlement with the stakeholders. So, in this background, the court observes in para 286. The next point which arises for consideration is whether the right under Article 29(1) can be invoked by the entire section of citizens aiming to preserve their culture or language, or if it can be invoked by a few individuals on behalf of the larger section of citizens. In this context, it becomes essential to examine previous decisions of this court where a violation has been put forth. Now the court summarizes the entire law on the subject. It refers to the Constituent Assembly debates, and in para 295 it summarizes. To sum up our discussion, the right conferred under Article 29(1) required that the state not take any steps to erode the community's culture, language or script, and concomitantly accords to such section of citizens the freedom and independence to preserve and conserve their culture, language and script by themselves. At the same time, the right under Article 29(1) does not necessitate the government to enact specific provisions for its enforcement, and also does not altogether restrict the state from enacting regulations. So now what this declaration is further explained. The court in para 300 says, we are not oblivious to the petitioner's demographic anxiety. We must be cautious of the impact our findings would have on the greater national landscape. Accepting the petitioner's assertion that a mere change in demographics is sufficiently actionable evidence of erosion of rights under Article 29(1) would have far-reaching consequences. We say so for the reason that it would undermine the idea of fraternity envisaged by our constitutional drafters. So therefore, they bring in the preambular concept of fraternity, which initial stage of the judgment the court has clarified is inclusive and not exclusive. So be it linguistic or cultural or other practices, it should be fraternity is to include people with diversity and not exclude people on this premise. And to bring to life their fears by threatening the cohesion of our diverse nation. It would open the floodgates for similar challenges by residents of other states who might seek to undermine Article 19(1)(e) rights and interstate migration under the guise of protecting their indigenous culture under Article 29(1). The Constitution of India, and indeed this court as well, does not envision India as a union of endogamous homogeneous territories. The cascading ramifications of accepting petitioner's stand on federalism and national harmony would be significant, deleterious and not improbable. In para 303, the court circumscribes the observations by holding this. At this stage, and given the restricted ambit of the present proceedings, this court cannot embark on a complex or microscopic fact-finding exercise to determine whether factually there has been any cultural erosion as alleged by the petitioners. So therefore, in a writ proceedings, as we know, undisputed facts can be taken note of. But when fact-finding is required, the writ courts usually refrain from returning any finding of fact which needs further detailed examination in a manner approved by law. So they sum up the rejection of the contention under Article 29 in para 304. So we thus sum up our analysis of the petitioner's claim under Article 29 holding that though they have the standing to make such a claim, but on the facts of the present case, they have failed to show either an actionable impact on Assamese culture or trace the cause of it to Section 6A. On the contrary, Section 6A, when read along with the larger statutory regime surrounding citizenship and immigration, mandates timely detection and deportation of illegal immigrants, a large portion of whom entered the Assam post 1971. Seen from this perspective, it is the non-implementation of the statutory regime which is the cause of the petitioners' concerns. Their attack on the constitutionality of Section 6A is misplaced. So challenge even on account of Article 21 also was rejected on similar grounds as the arguments on 29 were rejected. So the court has now identified the concerns of the petitioners, namely the illegal migrants occupying their landscape, and highlights the object of Section 6A was not merely to grant citizenship, but a positive obligation on the state machinery to identify people who have entered Assam post 25/3/1971, which is more than 5 decades now, and deport them. And this is the essence, as I see, of the judgment, that people who have managed to enter and who have been conferred rights cannot be now undone on any of the grounds that they have raised. But does it stop the states from actually undertaking the necessary steps to deport people who have come from after 25/3/71? So there is a positive mandate which has now been acknowledged or approved by the court in Section 6A, that people who have come post 25/3/71 for the past 5 decades or their descendants would not be given the benefit, because the citizenship rights by descent, by birth, is for people who are not born out of illegal immigrants. So that is the qualification of the Citizenship Act itself. So if I may just skip to the conclusions, because I think we are closing, reaching the time, it's already 10 minutes to go. I would like to wind up by reading the conclusions, which are very telling. Drawing upon the comprehensive analysis presented in the preceding sections, we thus hold that Section 6A falls within the Constitution and does not contravene the foundational principle of fraternity, nor does it infringe upon Article 6, 7, 9, 14, 21, 29, 326 or 355 of the Constitution of India. Furthermore, Section 6A does not clash with any established principles of international law. Hence, the constitutional validity of Section 6A contested before is resolved accordingly. Nevertheless, it is imperative to acknowledge and address the valid concerns raised by the petitioners regarding the persistent immigration of the state of Assam post 25/3/71. Although Section 6A conferred citizenship rights exclusively to immigrants arriving before this cutoff date, there seems to still be an ongoing influx of migrants through various border states of India. Due to porous borders and incomplete fencing, this unceasing migration imposes a significant challenge. On account of these concerns, we passed an order on 7/12/23 and directed the respondent Union of India to provide data inter alia the estimated inflow of illegal migrants into India after 25/3/71, the number of cases presently pending before the Foreigners Tribunal for such immigrants, and the extent to which border fencing has been carried out. Regarding the inquiry into the estimated influx of illegal migrants post 25/3/71, the Union of India was unable to provide precise figures due to the clandestine nature of such inflows. This underscores the necessity for more robust policy measures to curb illicit movements and enhance border regulation. Additionally, it was disclosed that approximately 97,714 cases are pending before the foreigners' tribunals, and nearly 850 kilometers of border remain unfenced or inadequately monitored. We hold that while the statutory scheme of Section 6A is constitutionally valid, there is inadequate enforcement of the same, leading to the possibility of widespread injustice. Further, the intention of Section 6A to restrict illegal immigration post 1971 has also not been given proper effect. Accordingly, we deem it fit to issue the following directions. In view of the conclusions drawn, it is held that Section 6A of the Act falls within the bounds of the Constitution and is a valid piece of legislation. As a necessary corollary, immigrants who entered the state of Assam prior to 66 are deemed citizens. Immigrants who entered between the cutoff dates 1166 to 25371 can seek citizenship subject to the eligibility conditions prescribed in Section 6A3. And immigrants who entered the state of Assam on or after 25371 are not entitled to the protection conferred by Section 6A, and consequently they are declared to be illegal migrants. So there is a positive declaration by the Constitution Bench. Accordingly, Section 6A has become redundant qua those immigrants who have entered the state of Assam on or after 25371. The directions issued in Sarbanand Sonowal are required to be given effect to for the purpose of deporting the illegal immigrants falling in the category of Direction B3 above. The provisions of Immigrants Expulsion and Assam Act 1950 shall also be read into Section 6A and shall be effectively employed for the purpose of identification of illegal immigrants. The statutory machinery and tribunals tasked with the identification and detection of illegal immigrants or foreigners in Assam are inadequate and not proportionate to the requirement of giving time-bound effect to the legislative object of Section 6A, read with the Immigrants Expulsion from Assam Act 1950, the Foreigners Act 1946, the Foreigner Tribunals Order 1964, and the Passport Entry into India Act 1920 and Passport Act 1967. The implementation of immigration and citizenship legislations cannot be left to the mere wish and discretion of the authorities, necessitating constant monitoring by this court. For this purpose, let this matter be placed before the Honorable Chief Justice of India for constituting a bench to monitor the implementation of the directions issued herein above. And that's how the majority has disposed of these proceedings. Now, as we all see, a great effort has been made on both sides to cull out the essence of the constitutional values. Views have been presented, debated, and a very balanced judgment has been delivered by the majority, which has in fact understood the purport of the political instability leading to the Assam Accord and the need for the political establishment to take decisions as are expedient as true representatives in a democracy of the electorate and the citizen, recognizing the limitations of the judiciary as much, being unelected to go into that sphere. The courts have, in certain areas of great moment and importance, chosen to exercise a continuous mandamus writ. T.N. Godvarman is one such case where the environmental degradation and forest degradation has been addressed by a continuous mandamus of these proceedings continuing. In these proceedings also, the court has expressed its desire to monitor further the implementation of Section 6A in its true spirit for those who have entered post 25th March 1971 with full rigor and force of the law, having declared them to be illegal migrants. The impact of this declaration is that it is binding on all authorities and all courts and tribunals across the country. So this declaration is no longer res integra for anyone else to interpret any further beyond what has been declared. I think this is the scope of this judgment, and in the limited understanding that I could comprehend this complex issue, both on account of its historical facts which are presented in the first part and the broad constitutional contours dealt with in the majority judgment here. Again, thanks Seshu sir for giving me this opportunity to present this judgment. Thank you very much, sir.
Thank you, Sridhar. In Part 1 and Part 2, nearly 221 pages judgment of Constitutional Bench he explained. He simply explained and we followed each and everything, and particularly Suryakant judgment and Section 6A and 7 and 9 and Article 29 also you explained. Thank you very much. We are all grateful to you as a youngster, promising senior advocate. So we are all highly grateful to you. Immediately 221 pages. It's not a ordinary thing. Now I request S. Geetanjali Sharma will give a vote of thanks.
Gratitude is not only the greatest of virtues, but the parent of all others. Good afternoon, all, as I take this opportunity on behalf of the Friday Group to express thanks. At the outset, I put on record our sincerest appreciation for today's speaker, Mr. Sridhar Potaraju, Senior Advocate, who delivered a very enlightening second and concluding part of the lecture on the Constitution Bench judgment dated 17/10/2024 regarding Section 6A of the Indian Citizenship Act 1955. On 25th October, at the 23rd Friday group meeting, in Part 1, Sir had discussed the genesis of the whole issue, its factual and cultural complexities, rooted in umbilical cord of various ethnicities and peoples. In today's Part 2 lecture, Sir painstakingly dived into details of the contours of the legal arguments presented before the Constitution Bench. It was explained that the constitutional validity of Section 6A of the Indian Citizenship Act 1955 was upheld, answering the challenge to the same in terms of the preamble, fraternity as a principle, Part 2 of the Constitution, power of judicial review, and federal structure. Sir also elaborated on the play and interplay of Article 6, Article 7, Article 11, Article 29, 326, Article 355, and how the case of Nisar Ahmed Khan was read by the lead judgment of Justice Surikant. We thank you, sir, for your ideas and elegance of explanation of everything. This vote of thanks shall be incomplete if I do not spare a word for all those present today in audience and all core members of the Friday group which help these lectures happen and thrive. Special thanks to the organizer and administrator of the Friday group, Mr. G.Seshagiri sir, who has held the group with unfailing zeal and remarkable consistency for almost a decade now. I conclude with a big thank you to each one of you.
Thank you, Geetanjali. So nicely explained vote of thanks. Friends, one more. This is the 5th volume. Today we are completing.
Oh, great. Archive will be there.
So that is 6th volume is ready.
Oh, good.
So it's more than
Two
several
more.
people signed and their mobile numbers and